Welcome back to SCOTUS Oral Arguments and Opinions. We continue with our case previews. Today, we preview Landor versus Louisiana Department of Corrections, which the court will hear on November 10th.
This case asks a question that affects every person incarcerated in a federally funded state or local facility. When prison officials violate your religious rights, can you sue them personally for damages?
And the facts here are pretty egregious. We're talking about a Rastafarian man who kept his religious vows for nearly 2 decades, only to have prison guards forcibly shave his head with just 3 weeks left in his sentence, even though the Fifth Circuit already held this exact practice violated federal law.
Right. And here's the constitutional tension. Congress passed a law called RLUIPA, the Religious Land Use and Institutionalized Persons Act, to protect religious exercise in prisons that receive federal money. But the lower court said that even when officials blatantly violate this law, you can't sue them for damages. You get nothing. So at stake here is whether federal civil rights laws have any teeth when it comes to protecting incarcerated people's religious freedom. Let's dive in.
The question presented is whether an individual may sue a government official in his individual capacity for damages for violations of the Religious Land Use and Institutionalized Persons Act. Now, to understand this case, we need to look at the key statutory text. RLUIPA says that a person whose religious exercise has been substantially burdened may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief against a government.
Let me read that again because 3 words in that provision are absolutely critical to this entire case. Appropriate relief against a government.
Right. So the fight is over what appropriate relief means and who counts as a government.
Exactly. And RLUIPA defines government to include 3 categories. First, a state, county, municipality, or other governmental entity. Second, an official or other person acting under color of state law. And third, this is the controversial one, any other person acting under color of state law.
Wait, so the statute explicitly says you can sue officials and people acting under color of state law. That seems pretty clear, that you can sue individual officers, right?
That's what Landor argues. But the Fifth Circuit read it differently. They said that even though the text says official and person acting under color of state law, you still can't sue them in their individual capacity for money damages. And this matters because RLUIPA's text is copied word for word from an earlier law called RFRA, the Religious Freedom Restoration Act, which applies to federal officials. And the Supreme Court already held in a case called Tanzin versus Tanvir that RFRA clearly allows individual capacity damages suits. So, Landor argues, same text, same result. If RFRA allows damages against federal officials, RLUIPA must allow damages against state officials.
All right, let's talk about what happened to Damon Landor, because the facts really drive home why this case matters. Landor is a devout Rastafarian. As part of his faith, he follows what's called the Nazirite vow, a biblical oath that prohibits cutting your hair. He kept this vow for almost 2 decades, and his dreadlocks fell nearly to his knees. In August 2020, Landor began serving a 5-month sentence in Louisiana State Prison. And here's an important piece of context. Just 3 years earlier, in 2017, the Fifth Circuit, the same appeals court that would later hear Landor's case, had ruled in a case called Ware versus Louisiana Department of Corrections that cutting a Rastafarian prisoner's hair violated RLUIPA.
So, Louisiana already knew this was illegal.
Exactly. And for the first 4 months, things went fine. Landor was held at 2 different facilities, and both respected his religious vow. No problems.
But then, with only 3 weeks left in his 5-month sentence, officials transferred Landor to a facility called the Raymond Laborde Correctional Center. And that's when everything went wrong. When Landor arrived, he informed the intake guard that he was a practicing Rastafarian. He presented legal materials about his religious accommodations. He even handed the guard a copy of that Ware decision, the Fifth Circuit case that said you can't do this. And the guard's response was to throw the materials in the trash and summon the warden. The warden demanded that Landor provide documentation from his sentencing judge corroborating his religious beliefs. Landor said he could contact his lawyer to get those documents. And the warden said, too late for that. Then officials brought Landor to another room, handcuffed him to a chair, held him down, and shaved his head to the scalp.
And it gets worse. After this assault, because that's really what it was, they kept Landor in lockdown for the remaining 3 weeks of his sentence. They denied him a grievance form, which effectively prevented him from filing a lawsuit until after he was released. So by the time he could sue, any claim for an injunction was moot. He wasn't in custody anymore, so there was nothing to enjoin. His only option was to sue for damages.
Right. So Landor filed suit against the warden, the secretary of Louisiana's Department of Corrections, and the John Doe guards who assaulted him. He sued them in their individual and official capacities under RLUIPA for money damages.
And the district court dismissed his case in a single paragraph. The court said, first, your claims for declaratory and injunctive relief are moot because you've been released. Second, we're dismissing your damages claims because Fifth Circuit precedent says RLUIPA doesn't allow individual capacity damages.
Side note, it's unclear how exactly the district court resolved Landor's claims against state officials in their individual capacity and Landor's claims against Louisiana. From my reading, it appears that the district court dismissed those claims on sovereign immunity grounds, basically following a 2011 Supreme Court decision, Sosaman versus Texas, which held that sovereign immunity bars RLUIPA claims against states. The claims against Louisiana and the individuals aren't at issue before the Supreme Court, only the claims against the officials in their official capacity. But I just wanted to add that detail.
Thanks for fleshing that out. Sosaman, a Justice Thomas opinion, features heavily in the parties' briefs. But let's not jump the gun. Back to the procedural history. Landor appealed the district court dismissal. The Fifth Circuit affirmed. And here's what's striking. The appeals court panel said they emphatically condemn the treatment that Landor endured. They clearly thought what happened was wrong, but they said their hands were tied by circuit precedent.
The Fifth Circuit panel held that, although RLUIPA's text suggests a damages remedy, recognizing as much would run afoul of the spending clause. They reasoned that because RLUIPA is spending legislation, it applies to prisons that receive federal money, only the funding recipient can be liable. And the funding recipient is the state, not individual officers. A divided court of appeals denied rehearing en banc. Judge Clement concurred in the denial of rehearing, joined by 8 other judges, called on the Supreme Court to resolve whether RLUIPA allows individual capacity damages. So Landor petitioned the Supreme Court, and the court granted certiorari to resolve this question.
All right, let's break down Landor's arguments. He advances 3 main points. First, he argues that RLUIPA clearly authorizes individual capacity damages through its text, and this argument starts with the Supreme Court's decision in Tanzin.
Right. Tanzin involved RFRA, which, as we mentioned, has identical remedial language to RLUIPA. Both statutes say you can get appropriate relief against a government, and both define government to include officials and persons acting under color of law. In Tanzin, the Supreme Court held that this language clearly authorizes individual capacity damages suits. The court said damages have been available in suits against government officials from the early republic through today.
And the court emphasized that Congress made clear that it was reinstating both the pre-Smith substantive protections of the First Amendment and the right to vindicate those protections by a claim.
Let me pause there to explain that reference. Before 1990, if a government official violated your First Amendment rights, including your free exercise of religion, you could sue them under a law called Section 1983 for damages. That was the standard remedy.
Then, in 1990, the Supreme Court decided Employment Division versus Smith, which dramatically weakened religious freedom protections. Congress responded by passing RFRA in 1993 to restore the pre-Smith protections. And when I say restore, I mean, Congress explicitly said it was reinstating not just the substantive rights, but also the remedies. So if damages were available under Section 1983 before Smith, they have to be available under RFRA and RLUIPA.
And Landor emphasizes that RLUIPA literally copied RFRA's text word for word. The statutes are what lawyers call sisters. They're interpreted together. So if Tanzin held that RFRA clearly allows individual capacity damages, RLUIPA must too.
Landor's second major argument is that damages aren't just appropriate, they're essential, and his own case proves this point.
Right. Landor had a short 5-month sentence. He was transferred twice. The assault happened with just 3 weeks remaining. And after it happened, officials kept him in lockdown and denied him a grievance form. So there was literally no way for him to get prospective relief, an injunction or declaratory judgment. By the time he could file suit, he'd been released, making those claims moot.
And this isn't unique to Landor. Most people in county jails serve sentences measured in weeks or months, not years. They're frequently transferred. Religious violations often happen suddenly, at intake, during searches, around dietary restrictions.
So if you eliminate damages as a remedy, you're essentially broadcasting to prison officials. You can violate RLUIPA with impunity as long as you do it to people with short sentences or people you're about to release.
Is that really what Congress intended when it said people can get appropriate relief?
Landor's third major argument is constitutional. He says RLUIPA's remedy is valid under Congress's spending clause power, especially when combined with the necessary and proper clause. The spending clause is Article 1, Section 8 of the Constitution. It gives Congress the power to collect taxes and spend money for the general welfare. Congress can attach conditions to federal spending. It can say, "We'll give you this money, but only if you follow these rules." And the key Supreme Court case on spending power is South Dakota versus Dole from 1987. Dole established that spending conditions are constitutional if they're unambiguous, related to the federal interest in the program, and not coercive.
So Landor argues RLUIPA clearly satisfies Dole. The condition is unambiguous. You can't substantially burden religious exercise. It's related to the federal interest. Congress wants to ensure prisons respect religious freedom. And it's not coercive. States can decline the money if they don't want to follow the rules.
But the Fifth Circuit said something more was needed. They said Congress can only impose conditions on the direct recipient of federal funds, the state. You can't reach individual state employees.
All right, so how does Louisiana respond?
First, Louisiana argues that RLUIPA is unconstitutional as applied to non-recipients of federal funding. And they start by emphasizing that spending legislation is like a contract. The Supreme Court has repeatedly said that when Congress conditions federal spending, it's analogous to a bilateral contract. The state agrees to follow certain rules, and in exchange, Congress gives them money.
And Louisiana says, in a contract, only the parties to the contract can be bound. The state is the party that receives federal funds and agrees to RLUIPA's conditions. Individual employees who don't receive the funds aren't parties to the contract, so they can't be sued.
Louisiana points out that over the past 25 years, an overwhelming majority of federal appeals courts have held that Congress's spending power is limited to imposing conditions on actual recipients. Courts have consistently rejected individual capacity suits under spending legislation.
Louisiana also emphasizes this isn't just abstract legal theory. States have been accepting federal prison funds for a quarter century on the understanding that individual employees couldn't be sued for damages. If the Supreme Court suddenly changes that understanding, it's unfair to the states.
Louisiana additionally argues that allowing suits against non-recipients would be unprecedented. They say there's no instance in American history where Congress has used its spending power to create a private damages action against someone who doesn't receive federal funds.
So Louisiana contends you'd need 2 layers of clear notice. First, clear notice to the state that it's accepting these conditions. Second, clear notice to individual employees that they can be personally sued. And Louisiana says the statute doesn't provide that second layer of notice.
Louisiana's second major argument is that even if the statute's language could be read to authorize individual capacity suits, it's not clear enough. They argue Congress needs to speak with extraordinary clarity when imposing conditions on spending. And they say three factors require heightened clarity here. First, federalism concerns. Holding state officers individually liable intrudes on state sovereignty. Second, the novelty of the claim. This would be unprecedented. Third, you need to notify both the state and the individual employees.
Louisiana also makes a textual argument about the word official in RLUIPA's definition of government. They say, sure, the statute says you can sue an official, but that doesn't clearly mean an official in his personal capacity.
Right. They point out that even Tanzin said the term official refers to the actual person who is invested with an office, but that statement does not articulate with the clarity required whether an official in his personal capacity is a government.
And Louisiana argues the phrase appropriate relief is inherently ambiguous. The Supreme Court said in a case called Sossaman versus Texas that this phrase is open-ended and inherently context-dependent. So Louisiana's argument is the combination of an ambiguous defendant class, official, plus an ambiguous remedy, appropriate relief, doesn't meet the clear statement requirement for spending legislation.
Louisiana's third major argument is constitutional, but it's really a backup. They say even if the statute is clear enough, the Constitution doesn't allow Congress to regulate non-recipients this way.
And they make some federalism arguments that are pretty interesting. They say if states can subject their own citizens to federal spending conditions just by accepting federal money, that undermines democratic accountability.
How so?
Well, imagine Louisiana accepts federal prison funding with RLUIPA conditions attached. Under Louisiana's argument, that means Louisiana has unilaterally consented to deprive its citizens, the prison employees, of certain freedoms. But those employees didn't vote on that. They didn't have a say. Louisiana argues this violates basic federalism principles. The framers designed our federal system so that liberty is protected through diffusion of power between state and federal government. But if states can subject their citizens to federal control just by accepting money, that breaks down the protection.
Louisiana also makes a practical argument about how states contracted for federal money. They say, for 25 years, the Fifth Circuit and many other courts have held that RLUIPA doesn't allow individual capacity damages. States accepted federal funds based on that understanding. So Louisiana argues you can't retroactively change the terms of the deal. When Louisiana accepted federal prison money, it understood the deal was the state can be sued, but not individual employees. You can't now say, surprise, your employees were always suable.
And finally, Louisiana hints at a much bigger constitutional problem lurking in the background. They suggest RLUIPA itself might be unconstitutionally coercive under NFIB versus Sebelius, the Obamacare case.
Oh, that's interesting. In NFIB, 7 justices held that conditioning all of a state's Medicaid funding on accepting Medicaid expansion was unconstitutionally coercive. The funding was so large that states didn't really have a choice.
Right? And Louisiana points out that RLUIPA is triggered in part by Medicaid funding to prisons. So if a state can only avoid RLUIPA by giving up Medicaid funding altogether, that might be the same type of coercion that NFIB struck down.
Louisiana says the court doesn't need to reach that issue because it can affirm on narrower grounds. But they want the justices to know this broader constitutional problem exists.
Now, there's a third party in this case. The United States filed an amicus brief supporting Landor, and the government makes some arguments that are slightly different from Landor's. We'll highlight these arguments because at the Solicitor General's request, the Supreme Court allowed the United States government to participate at oral arguments. The United States' first major argument is textual. They emphasize that appropriate relief in RLUIPA clearly includes damages based on Tanzin and the statute's context. The government points out that Tanzin held RFRA's identical language clearly authorizes individual capacity suits. and the court explained that damages have always been available under Section 1983 for First Amendment violations.
The government also emphasizes the textual contrast we mentioned earlier. Congress limited the federal government's enforcement to injunctive or declaratory relief, but gave private parties appropriate relief without limitation. That has to mean private parties get something more, namely, damages.
The United States' second major argument is about who can be sued under spending legislation, and they make a point that's critical. Government officials are agents of the funding recipient.
Right. In contract law, when you make a contract with a corporation, you can hold the corporation's agents accountable for performing the contract. The agents aren't strangers to the contract. They're the means by which the principal performs. So the United States says the state is the funding recipient. Prison officials are the state's agents. When Congress says the state can't burden religious exercise, that means the state's agents can't burden religious exercise, and Congress can authorize suits against those agents to ensure compliance.
The government emphasizes the Supreme Court's decision in Rust v. Sullivan, which held that employees of federally funded projects have voluntarily undertaken to execute the state's obligations under the federal spending contract as a consequence of their decision to accept employment.
So it's not that Congress is reaching out and regulating random citizens. It's reaching the state's own agents who voluntarily chose to work for a federally funded program.
The United States' third major argument concerns the Constitution's necessary and proper clause. They argue Congress has broad authority under this clause to ensure taxpayer dollars are properly spent. The key case here is Sabri versus United States, which we mentioned earlier. In Sabri, the Supreme Court held that Congress has corresponding authority under the necessary and proper clause to see to it that taxpayer dollars appropriated under that power are in fact spent for the general welfare.
And if Congress can regulate members of the general public who interfere with federally funded programs, as Sabri held, it certainly can regulate government employees who are agents of the funding recipient. The United States also provides practical examples of how Congress has repeatedly imposed liability beyond direct recipient. For instance, the Emergency Medical Treatment and Active Labor Act imposes civil penalties on individual physicians who work at federally funded hospitals.
Right. Congress has created whistleblower protections for employees of government subcontractors. It's imposed liability on private individuals who administer federal grants. This isn't a novel exercise of power. It's consistent with long-standing practice.
So, the United States argues the combination of clear statutory text, the spending clause authority, and the necessary and proper clause make RLUIPA's damages remedy clearly constitutional.
All right. The High Court set oral arguments for November 10th. What will you listen for?
I'm really curious to see how the justices react to the practical scenarios. When Landor's lawyer talks about cases like his, where someone has weeks left in their sentence, there's a sudden violation, and any prospective relief is immediately mooted. Do the justices seem troubled by leaving victims without any remedy? I'll also be listening for questions about Tanzin's scope. Several justices might push back and say, Tanzin was about RFRA, which applies to federal officials. Federal officials don't have 11th Amendment immunity, but state officials do. Maybe that difference matters. Although Landor would respond, that's exactly why you sue them in their individual capacity rather than official capacity. Individual capacity suits overcome sovereign immunity.
Those will surely be hot topics. I'm curious whether any justices will engage with the Salinas argument, because if Salinas really is on all fours with this case, officer in a federally funded jail, misconduct threatening the program, that seems pretty dispositive.
Right. But Louisiana might argue Salinas was a criminal case, not a civil case. And criminal penalties have always been different from civil damages in the spending clause context.
Although I'm not sure that distinction holds up. The constitutional analysis in Salinas was about Congress's power under the spending and necessary and proper clauses. The court didn't say that analysis only applies to criminal cases.
I'll be watching for federalism questions. Do any justices express concern that this could subject state employees to unpredictable liability? Justice Alito and Justice Thomas in particular tend to be sensitive to federalism issues. Although Landor might respond, these aren't unpredictable claims. RLUIPA has been on the books since 2000. Prison officials know they can't substantially burden religious exercise. If they violate that clear rule, they should face consequences.
Another thing I'll be listening for: do the justices seem concerned about the implications for other spending statutes? If you allow individual capacity damages under RLUIPA, what about Title IX? What about the Americans with Disabilities Act?
That's a good point. Louisiana is going to argue this opens the floodgates. But Landor will respond, RLUIPA has an express private cause of action that says appropriate relief. Title IX doesn't. So the statutes are different.
Plus, the United States pointed out that allowing individual capacity damages here wouldn't necessarily affect Title IX because Title IX doesn't have the same acting under color of state law language that RLUIPA has. I'm also curious whether any justices will engage with the supercharged clear statement rule debate. Does Louisiana really need Congress to use magic words like, you can sue individual officers for money damages?
Right. Because if you require that level of specificity, you're essentially creating a one-way ratchet where it's easy to create substantive obligations, but almost impossible to create effective remedies to enforce them. Two cases may feature in this part of the analysis: Talevsky and Medina versus Planned Parenthood South Atlantic.
So why does this case matter? At the most basic level, it's about whether federal civil rights laws that protect religious exercise have any enforcement mechanism.
Right. Congress passed RLUIPA to protect incarcerated people's religious rights in federally funded facilities. But if the only remedy is prospective relief, injunctions and declarations, then people with short sentences or people who experience one-time violations will never get relief. And the lack of a damages remedy means there's no real deterrent. Prison officials can violate RLUIPA knowing that even if they get sued, the worst that happens is a court tells them to stop. But by then, the person's been released or transferred. So even that remedy is meaningless.
This case also may more broadly implicate how we understand the spending clause. Does Congress's power to attach conditions to federal spending reach only the entity that receives the money, or does it extend to that entity's agents and employees? That question affects lots of federal programs beyond RLUIPA: education funding, healthcare funding, social services funding. In all these areas, Congress attaches conditions to federal money and expects those conditions to be followed.
And if the court sides with Louisiana, it could make it much harder to enforce those conditions. You might be able to sue the state or the institution, but you couldn't sue the individual employees who actually committed the violation. Ultimately, the decision in this case could come down to how the justices balance several competing values: protecting religious liberty, respecting federalism, ensuring effective remedies for civil rights violations, and maintaining clear limits on federal power.
We'll be covering the oral arguments in detail when they happen on November 10th. This is the kind of case that could produce sharp questioning from across the ideological spectrum.
And when the court issues its decision, we'll break down the opinion and what it means for incarcerated people's religious rights going forward. Thanks for listening to SCOTUS Oral Arguments and Opinions. If you enjoyed the content, please follow, rate, and share the podcast. In our next episode, we'll cover Geo Group, Inc. versus Menacol, a case that will attempt to answer whether an order denying a government contractor's claim of derivative sovereign immunity is immediately appealable under the collateral order doctrine. That's a mouthful, but we'll break it all down.
I look forward to that discussion. Talk to you soon.